So my name is Wendy Weiser, and I direct the Democracy Program at the Brennan Center for Justice at NYU Law School, and I am delighted to moderate this important panel on voting rights after Shelby County. By way of introduction, as you've no doubt heard, and might be why you're here, we're in the midst of a very high-pitched battle over voting rights in America right now, with states across the country passing laws and executive actions that would make it harder for eligible Americans to vote. And while this has been going on in a few places for about a decade now, this battle has really picked up intensely after the 2010 election, when lawmakers flooded state houses for the first time with, in 41 states with legislation to cut back on voting. And we just put out this past week a report just looking at the cumulative effect of this movement, and it's really quite sobering. And I just want to throw out a couple of numbers. If nothing changes between now and the 2014 election, Americans in 22 states will face new voting restrictions that were not in place in 2010. In other words, we will see nearly half the voters in the country will find it harder to vote in 2014 than they did in 2010. In 15 states, 2014 will be the first election where these, federal election, where these new restrictions will be in place. And this is voter ID restrictions, but it's also cutbacks on early voting, cutbacks on voter registration, and laws making it harder to restore voting rights for people with past felony convictions. And court cases are also something that make a big difference, and there are 7 states right now that have major court cases pending that could change the outcome of these 15 states or 22 states. And while there are different perspectives on what's going on, I just wanted to flag 3 big features of these new laws and of this movement. First, it is highly partisan. In virtually all of these states, the new restrictions were put in place by entirely Republican-controlled bodies, and in the few exceptions, they were generally much less restrictive. Second, race has been a critical factor. In 7 of the 11 states with the highest African-American turnout have new voting restrictions, as do 9 of the 12 states that saw the highest increase in Hispanic population growth over the last decade. And there were 2 recent social science studies that actually put some statistically significant, strong findings showing that how strongly race correlated with these new restrictions. And third, courts have been a really important bulwark. Not only are there current cases in 7 states, but many of these new voting restrictions have found their way in court. And for the most part, so far, the voting rights advocates have been winning. And in the lead up to the 2012 election, the biggest, but not the only source of legal victories was Section 5 of the Voting Rights Act, and that's the provision that required certain states with a history of voting discrimination and jurisdictions to get federal pre-clearance before implementing new voting changes. And then everything changed. Almost a year ago today, next week is the anniversary, in the Shelby County decision, the Supreme Court gutted Section 5, which was the most powerful provision of the Voting Rights Act, and it said that the formula Congress had used to choose which states will be covered was outdated. And the effect of that is, in the midst of what many agree is the biggest assault on voting rights since the Civil Rights era and the biggest legislative movement to restrict voting since Reconstruction, voting rights advocates have lost one of their most powerful tools to fight back. So we have an excellent panel right now to help us understand the voting landscape after Shelby County. What has been the impact of that decision? What should we do about the Voting Rights Act? What other tools do we have to protect the right to vote? What other things should we be concerned with in the voting area? And these questions are taking on in particular importance today also as we approach the 50th anniversary of Freedom Summer, which is coming up shortly. And I'm going to give only very short introductions. The programs have detailed bios. The panelists all have really impressive credentials and histories of work, long histories of work on voting rights issues that I urge you to read. To my immediate left is Gilda Daniels, who's an associate professor at the University of Baltimore School of Law. To her left is Sam Issacharoff, the Reese Professor of Constitutional Law at NYU School of Law. To my right is Arturo Vargas, who is the Executive Director of the National Association of Latino Elected and Appointed Officials. And to his right is Dale Ho, the Director of the ACLU Voting Rights Project. So I am honored to be moderating this panel today, and I'm going to start with a question for all of the panelists. The Shelby County decision hit when this big battle was already underway. But to all of you, what has been the impact of the Shelby County decision, and how does it affect where we are today? I'll start with you, Gilda.
Thank you, Wendy. Good afternoon. Okay. To make sure we wouldn't be talking to ourselves today, because we very much want this to be a conversation. Thanks to ACS for having this panel, and so that we can have an opportunity to talk about this very important subject. I'd like to start talking about what we lost with the Shelby County decision, particularly in regards to Section 5. And what we lost was, excuse me?
Put it a little closer.
Closer. I thought, okay, closer. Okay, so I'd like to start by talking about what we lost in the Shelby County decision, and particularly in what we lost in Section 5. While the Supreme Court found that Section 4B was unconstitutional, which was the coverage formula, in essence, as you all know, it essentially has left us without one very important tool in the Voting Rights Act. So what we lost under Section 5 was preemption. Right? No longer are covered jurisdictions required to submit their voting changes for approval prior to implementation. And another thing that we lost was the deterrent effect, that they're essentially the function that would caution jurisdictions from implementing or passing legislation that could be discriminatory. And also notice, right? Now, because the jurisdictions no longer have to present their voting changes, whether it's moving a polling place across the street to a congressional redistricting, to a higher authority, be it either the Attorney General for the United States or the United States District Court for the District of Columbia, those kinds of changes don't get the kind of vetting that they once did under Section 5 in trying to determine whether or not the change could actually put minority voters in particular in a worse position. Now, since the Shelby County decision, since we don't have preemption, don't have deterrence, and are now lacking notice or transparency, as many of you know, the day that the Shelby County decision was announced, states went into action, right? You had states like Texas that immediately, the Texas Attorney General announced that it would implement a voter ID law that a court had found was intentionally discriminatory. Right? And the court said that there were almost 800,000 registered Texans that lacked the required ID, and that the burden of this new ID requirement would fall on Hispanic and African American voters. So immediately after the Shelby County decision was announced, you had that kind of response in Texas, not only for their voter ID laws, but also for their redistricting maps, which had also been found intentionally discriminatory by a court. In Georgia, you had jurisdictions, even on a local level. I used to live in Atlanta when I worked for the Southern Center for Human Rights, and you weren't familiar with Stephen Bright and the Southern Center for Human Rights, right? And I always told people that Atlanta is not Georgia. Is anybody here from Georgia? Can you? You would agree, wouldn't you? Atlanta is not Georgia. Well, in Fulton County, so now Atlanta is not even Fulton County, right? So the Fulton County Commission decreased the size of majority-minority districts since the Shelby County decision. In Athens, Georgia, they closed almost half of their 24 polling places and replaced them with 2 early voting facilities located in police stations. Closures that would force some voters to travel 3 hours to reach the new polling places. In Greene County, Georgia, the County Board of Commissioners revised its redistricting plan, decreasing the percentage of African American voters in a majority-minority district to less than 51%. And as many of you know, Georgia is a previously covered Section 5 jurisdiction, and those kinds of changes would have had to have been pre-cleared before implementation. Also in Augusta, Richmond, Georgia, officials wanted to move its county elections from November to the summertime, when you traditionally not only have poor turnout, but poor African-American turnout. Then nobody turns out in the summertime. We're about to experience that in Maryland. We have a primary next week on June 24th. But in Georgia, they originally sought to move the Augusta elections to July, but ultimately they were moved to May, with runoffs being held in July. Again, those kinds of changes are changes that would have to have been pre-cleared, but without Section 5, without having the deterrence, or certainly having the preemption effect is no longer in effect. And there are also, issues with North Carolina. Of course, you've seen Moral Mondays on the news, and the kind of plans that legislation has in regards to cutting early voting by a week, restrictive voter registration, all of those those kinds of changes would have been, had to have been vetted through the Attorney General or the United States District Court for the District of Columbia prior to implementation, but without Shelby County, without Section 5 and under Shelby County, that no longer exists.
And Arturo, from the perspective of the Latino community in particular, how has the impact of Shelby County been felt, and what are you seeing, and what are you concerned about?
Right, thank you, and good afternoon. First of all, full disclosure, I'm not a lawyer. Saying to a room full of lawyers, I imagine all of you are. It's been actually quite devastating. 1 out of 3 Latinos prior to the Shelby decision was actually covered by Section 4 and Section 5, or lived in jurisdictions that were covered. So that's now 7 million Latinos who no longer have these protections, 7 million Latinos eligible to vote in those jurisdictions. The most egregious of those jurisdictions being Texas. So Gilda already talked about how the Attorney General has moved to implement the voter ID law, and hovering right behind that is looming right behind that's a possibility that Texas will again move to try to redistrict its congressional and state legislative lines in ways that it has done previously to intentionally discriminate against Latino voters in that state. The Supreme Court itself had found intentional discrimination by the state of Texas against Latino voters, and unabashedly, the Texas legislature would proceed with continuing that kind of discrimination. Now, they allege that what they're doing is actually quite partisan and trying to preserve a Republican majority. But in so doing, they are acting in ways that limit the opportunity of Latino voters to elect candidates of their choice. So the impact on Latinos in Texas is quite severe, and something that we're hoping can be restored with a legislative fix. But some of the other jurisdictions are just as bad. Arizona no longer has any protections or is subject to any preclearance. Arizona is another state that in recent years has been quite anti-immigrant with SB 1070 and other actions to limit the impact of immigrants. What we are most concerned about is if we look at where Latinos are growing throughout the country, that the greatest increase of Latinos has been in the South, in North Carolina, in Arkansas, in Tennessee, and in Florida. And in these jurisdictions, what we have seen is that as Latinos grow and as they start becoming a impactful element of the electorate is when we begin to see reactions to the number of Latinos who are beginning to vote, whether it's requiring proof of citizenship to register to vote, voter ID, English-only provisions, limitations, even where federally required, on language access in voting. Section 203 of the Voting Rights Act requires that when a jurisdiction has a certain threshold of a language minority of the same language group and low levels of English literacy, that language assistance must be provided in that particular language. We know that jurisdictions are refusing to provide language assistance. And now there is no protections in those areas where Latinos are growing that were previously covered by Section 4 and Section 5. The only saving grace in this, from our perspective, is that we're hoping that as we try to come up with a legislative fix of the Shelby decision, that perhaps we can work with the Congress to come up with a new formula, a new strategy, or a new way of protecting voters that doesn't just apply to these jurisdictions with the long history of discrimination and which continue to do discrimination, commit discrimination against Latino voters, but also looks to create a law that can be proactive and see how we can protect voters in jurisdictions where the Latino electorate will continue to grow and have an impact. And we know there will be efforts to try to limit the impact of Latino voters. So it's a dynamic situation in which we're in. Great protections were lost, particularly in Texas and in Arizona, some counties in Florida, and where Latinos are growing. But I think now we have an opportunity to try to come up with a new paradigm to see how we can protect voters, Latino voters, where the electorate is growing.
And Sam, do you want to pick up on this dynamic situation and talk a little bit about not only to what extent what's going on relates to the Shelby County decision, but some of the direction you would like to see the conversation go in for how to fix that problem?
Well, it seems to me that there's two different questions that have to be asked. The first is, how effective was Section 5 prior to Shelby County in actually curtailing retrograde election practices in the United States? My particular view, something I testified about in the Senate in 2006, is that Section 5 had largely run its course, and that increasingly the types of issues, the types of places where we had significant voting problems in the United States were poorly matched onto the regulatory framework of Section 5. So you can chronicle that there are problems in jurisdictions covered by Section 5. You can say that Section 5 no longer covers them in the way it did prior to Shelby County. Whether that shows that Section 5, had it remained in force, would continue to be effective, particularly since most jurisdictions that were covered and that were aggressive in the way I'm about to describe had already settled upon the practice of going directly to the DC District Court and filing suit affirmatively. And it is true that they bore the burden of proof rather than the normal civil justice burdens of proof. Most of these cases don't turn on that marginal effect of the burden of proof at trial. So it's a question, at least to me, how effective Section 5 was to begin with and how much was lost on that score. But I think the bigger problem is, what is the source of the impulse right now, the post-2010 changes that the Brennan Center has so well documented? In 2008 and in 2012, roughly 60% of the eligible population voted in American federal elections. In 2008 and 2010, the Democrats won the presidency, the Democrats picked up seats in Congress, the Democrats picked up seats in the Senate. In 2010, roughly 46–47% of the eligible population voted, a 15 base point decline from 2008, and the Republicans cleaned house. From that comes the conclusion that both parties knew in the 2012 presidential election, when I was one of the lawyers for President Obama, both parties knew what the election was about. It was a turnout game. And the turnout game has been Democrats try to promote turnout and Republicans try to retard it, because there's a predictable partisan outcome to that. So if you look at the states where restrictive voter registration or voter ID or curtailments have been put into place since 2010, there's only one operational variable that you need to pick out, and that is, are the Republicans in control of that state? In virtually every one of these 22 states, the Republicans control the operational lever. Either they have the Secretary of State, they have the governor, they have the legislature, or they have them all. You look at the states that have now had the most restrictive reforms since 2010. I think that the poster kids for this particular wonderful development of American democracy are North Carolina and Wisconsin. One is a state that only has a few counties covered under the Voting Rights Act under Section 5 previously. The other one has never been a covered jurisdiction under Section 5. You look at the types of laws that emerge in states that have significant minority populations and non-significant minority populations, and you see that the same bills written by the same ALEC organization that drafts them are being put into place so long as the Republicans have control. So the question that I think we're going to get to slightly later, to my mind, is if this is true, if there is a huge partisan valence to it, which overlaps, correlates no doubt, with race in many jurisdictions, not all, but in most, what is the most effective way to think about it? Is it to go back to a civil rights model drawn up from turnout statistics from the 1964 presidential election, or is it to think about this in a different manner that recognizes that in the post-Bush v. Gore, post-Florida 2000 period, we have unfortunately come to learn, sometimes to our surprise, that manipulation of the election rules can often be the best way possible to achieve a desired partisan outcome. And if that's the source of the concern, the 1964-based coverage formula of 1965 Voting Rights Act, it would be pure serendipity to have that map on directly to the problems as they exist today.
And before we get to the second point, I'm going to turn to Dale to address the first point that Sam made. He challenged or asked how effective Section 5 really was to begin with. And as we're sort of talking about the impact of the Shelby County decision, if you can reflect on that and a little bit on what we've lost, maybe from the perspective of somebody who's litigating both before and after the loss of Section 5.
No, sure, I'd be happy to talk about that. So I think there are four things that I want to say really quickly. The first two are about the effectiveness of Section 5 and what we lost with Section 5's effective demise, and two things about the impact of Shelby County in the contemporary voting rights landscape. So what we lost with Section 5 and the effectiveness of it. I think Sam is absolutely right that there are voting problems that we have seen over the last few years in places outside of the formerly covered jurisdictions, and there are places where the most high-profile activity have been in places like Ohio or Wisconsin. Now, that being said, right, those kinds of high-profile statewide voting disputes are ones that there's a lot of incentive for the big players, the political parties, or the larger civil rights organizations to get involved in, right? What we lost with Section 5, I think most significantly, was its effect at the local level. Now, Gilda talked about some examples of some voting rights restrictions that have been happening at the local level since Shelby County was decided, but the truth is, there's probably a lot more out there that we just don't know about right now because we lost Section 5's notice function. Between 1982 and 2006, the last Section 5 reauthorization period, over 80% of objections took place below the state level, right? And those are the kinds of cases where there's just not a lot of attention that the national organizations can frankly afford to bring to problems. It's simply not cost effective for those groups. So yes, there have been high profile problems in places like Ohio and Florida over the past 15 years, but those are places where, you know, that are generally, relatively speaking, obviously because nothing's perfect, but comparatively well resourced when you compare it to the local jurisdictions where we actually see a tremendous amount of voting rights activity and where we unfortunately don't know everything that's happening there now without Section 5's notice function. The second thing I want to say, though, about Section 5's effectiveness and what we've seen in recent years is that it's actually been also effective at the statewide level. So I don't mean to downplay that. So let's take a look at the 2012 election cycle, for instance, right? Texas's strict voter ID law blocked under Section 5, right? Early voting cutbacks in Florida. The proposal to reduce the number of hours of early voting, right, in Florida, to cut them in half in 5 counties that were covered by Section 5, also blocked by Section 5. You may remember one of the most, I think, sort of famous details about that case is that Florida eliminated discretion of counties to have voting on Sundays, right? which I think we all understand, like why Sunday is a particularly significant time for African American voters, right? African American voters, about 20% of the electorate in Florida, but over a third of the voters on Sundays, right? So if anything made Florida's early voting cutbacks transparent, it was that particular feature. And then also South Carolina's voter ID law. It was allowed to be implemented under Section 5, but not until, over the course of litigation, South Carolina essentially adopted an exception to the law that enabled anyone without an ID to essentially cast a regular ballot on the basis of any reasonable justification for not having ID. So I think Section 5 was quite successful in 2012 at blocking some of these voting restrictions. Now, Sam makes this point that you could bring a Section 2 case, and yeah, the burden of proof is different in Section 2, and how much does that really matter? And in theory, I agree that it should actually make very, very little difference if the burden is on the people whose voting rights have been violated or the jurisdiction, right? Because it's very rare that you have a case where the evidence is exactly 50-50 in equipoise, right, between the nominal plaintiff and the jurisdiction. The reality is that even though there's no sort of statutory justification for this, is that I think the placement of the burden of proof as a practical matter affects the way that courts weigh the evidence, right? And to go back to 2012 in Florida, right? So I mentioned 5 counties covered by Section 5, early voting reductions blocked under Section 5. In the rest of the state, right, those early voting reductions were implemented, notwithstanding a Section 2 challenge, which a court dismissed, right, on almost the identical record, right? So the record is almost exactly the same, but the court actually invokes the sort of difference in the evidentiary standard in Section 2 and Section 5 cases, and in the Section 2 case allows the early voting cutbacks to go into effect. So I think it's actually quite consequential, right, where the burden of proof lies. 2 other things really quickly before I stop. What has been the impact of Shelby County, right? There has been a lot of activity in the formerly covered jurisdictions in the last year, right? Wendy mentioned that 22 states have enacted voting restrictions. Here are some examples from formerly covered jurisdictions, right? Alabama, Mississippi, Virginia all moved to implement their voter ID laws in the weeks after Shelby County. Arizona goes forward with its plans previously blocked by the Supreme Court to implement proof of citizenship laws, and says that if they can't do that, they're going to have a dual registration system where if you've registered to vote with a federal form, you can vote for federal offices like president, just not the really important state offices like dog catcher, right? North Carolina, obviously the worst of the bunch, not only a strict ID law, but cutbacks on early voting, very consequential. Over half of voters in North Carolina used early voting. Eliminate same-day registration, again, very consequential. Over 100,000 voters registered with same-day registration during the last 2 presidential elections, and a host of other bad things. Now, I think Sam's absolutely right. There's a lot of activity outside of the formerly covered jurisdictions. But I think that's always been the case, right? It's not that the covered jurisdictions have been the only places in the country where there have been voting rights violations. And obviously, I'm not here to relitigate Shelby County. We lost, right? We have to accept that. But right, I don't think the fact that there are continuing voting rights violations outside of the formerly covered jurisdictions should be seen as, in some sense, vindicating the court's rationale in Shelby County, because these things are interrelated. Things that happen in the formerly covered jurisdictions affect things that happen outside of those places. And I think we see that in terms of the cross-pollination, in terms of the types of voter suppression that we're seeing in different states.
And Gilda, did you have a response to this as well?
I did. I'm troubled by assertions that Section 5 was not an effective piece of legislation. I'm a former deputy chief in the Department of Justice Civil Rights Division voting section, where Section 5 used to live. And I've seen firsthand how important Section 5 is on the local level, particularly for things like candidate qualifications, polling place changes. Those kinds of changes were certainly very important to the Section 5 process in ensuring that voting changes did not have a purpose or effect to discriminate. And I think that we can't get lost in this discussion. I think maybe part of what we need to think about in regards to Section 5 is when we're talking about why not Ohio, that is a good, why not Ohio? Ohio could certainly be one of the states that should be covered, as well as Pennsylvania, as well as Wisconsin, as well as Missouri, or even Kansas, right? So, and there's a question of whether or not, why aren't we looking at legislation to expand the protections of Section 5 as opposed to reduce or eliminate, right, which is what the Supreme Court did, was eliminate Section 5 altogether, and hopefully we can change the conversation to talk about expanding those protections as opposed to reducing them or eliminating them.
And that's a perfect segue to the next question, which I think will, which is the legislative response. Let's start looking forward now. And within a few months of the Shelby decision, a bipartisan group in Congress introduced the Voting Rights Amendment Act to, as a fix to the Shelby County decision to modernize and to modernize the Voting Rights Act in light of the Supreme Court's decision. And there's going to actually be a hearing on this next week on the anniversary of the decision in the Senate Judiciary Committee. And that's not the only hearing going on in the Senate Rules Committee. There's going to be a hearing on proposals to expand early voting that came out of one of the big recommendations that the Presidential Commission on Election Administration issued. This was a commission that it was a bipartisan commission that President Obama established before the Shelby County decision in the wake of the 2012 elections and all the problems that we saw there, and especially the long lines, to try to come up with affirmative voting policies that might be able to be adopted in states across the country to reduce long lines. And so, looking at with those two those two options going forward, and the articulation of the problems that everyone set up, what is the path forward? What should we do in the wake of Shelby County? What do you want to see happen legislatively or otherwise? And I see Sam was anxious to respond. So I don't know if that was to this question.
Well, it is in part. I mean, look. Undoubtedly, Section 5 was a big piece of legislation. It covered many things. We're here to talk about voter ID practices, about early voting eligibility, about certain kinds of statewide conduct. To say that Shelby County covered a lot of things at the local, Section 5 covered things at the local level is fine, but is irrelevant to the topic under discussion here, most of which has to do with statewide practices. And if we're talking about statewide practices, these are matters of high profile. The parties do get involved and so forth. Now, the question is, what lessons should we take from the experience of the 20-plus states that have enacted these pieces of legislation where there has been affirmative litigation against them? And there has been litigation in almost all the states that have tried this, and the litigation has been spectacularly successful in rolling this back in almost every state. And the litigation, it is true that in Texas, in Florida, in South Carolina, not South Carolina is more complicated, but it's true in Texas and Florida, there was some effect from Section 5 of the Voting Rights Act. I would say that the biggest effect that we've seen in the post-2010 period has been the emergence of doctrines wholly crafted by the courts, based of all things on Bush v. Gore, in which they strike down these practices as unconstitutional. The leader in this is the Sixth Circuit. The Sixth Circuit has no covered jurisdictions within it. Well, it has 2 counties in Michigan, but irrelevant. What you have is the emergence of new doctrines to deal with a new problem. So you're going to have a Voting Rights Act amendment. It's a peculiar piece of legislation. It doesn't cover Alabama, for example. It's hard to think of a classic civil rights-inspired law that doesn't cover Alabama. But okay, that's what this coverage formula comes up with. But the question is, let's not always fight the last war. The question is, what can you pass? One question is, what can you pass that you can get through Congress, and whether you can get anything through Congress is another matter, but what could you pass that would survive Supreme Court review? And you could probably tweak some version of Section 5 in a way that would pass constitutional muster. The question is that really going to be effective, and is that where the best deployment of resources would be? Why not instead look at the success that there has been in court under state constitutional law in Pennsylvania, under federal constitutional law in Ohio and other places, and ask the question, is there a source of federal authority that can be brought to bear that is not triggered by the 14th and 15th Amendments, so it doesn't have some of the Shelby County disabilities? And we had, the same year as Shelby County, we had the Arizona intertribal case, which recognized tremendous federal power over federal elections that is not triggered by the 14th and 15th Amendment considerations. And you could have a system that responds to making easier the kinds of litigations that have taken place under the Constitution directly. Now, I engaged in a lot of this litigation when I was counsel for the Obama campaign. It may come as a surprise to you. We had substantial resources in the Obama campaign, and we could put a lot of really good people to work on these kinds of cases, kinds of resources that are not generally available. But there are ways of easing that litigation that don't turn on the preclearance model. So for example, you could have a nationwide practice that any change in voting practices at all, or within a fixed period of time, a year of a general election, a year of a federal election, has to be submitted to the Department of Justice, not for preclearance, just for certification that the change has been done, a reason why the change has been done, and filed with them. This is the SEC model of enforcement. This is allowing effective private enforcement by making it easier to sue the way we make it easier to sue over securities fraud. And that's a different regulatory model that is not based on the idea that we are basically carrying forward what happened in the 1960s, and we are really concerned with recalcitrant parts of the country that have not gotten the message that the days of Jim Crow are over. What we have now is a different situation. We have a situation where, unfortunately, with some overlap with the Jim Crow practices of the past, but unfortunately the lesson is go after people's ability to vote in order to shift the partisan outcome of the elections.
So the courts are undoubtedly critical players here, and we're going to get to that next. I would like Arturo to talk a little bit about why you support the Voting Rights Amendment Act, maybe to provide a counterpoint and, and a little bit of context for that.
Yeah, well, to be candid, it took us quite a bit of time and thought to really determine that we fully supported the Voting Rights Act, because it is not a perfect piece of legislation. It is notable that it is bipartisan, and that's something very rare to find in Congress today. And in order to get that, there were significant compromises that were reached. Now, one comment on the whole notion of why Alabama's not covered and other jurisdictions that were previously covered would not be covered by the new formula really speaks to the strength of what previously was in place in Section 5 and Section 4. The new formula would only cover those jurisdictions that have committed violations of the Voting Rights Act over an immediate past amount of time. So in the past 10 years, if a state had committed 5 violations of the Voting Rights Act, they would be covered under the new law, and it would be a rolling trigger. Now, some jurisdictions would not be covered that should be covered, or previously were covered, because those violations did not occur, because they were prevented from committing those violations by Section 5. So that really speaks to how, what really was lost. So under the new formula, 4 states would be covered: Georgia, Louisiana, Mississippi, and thankfully Texas. Possibly 24 additional jurisdictions would be covered as well. But what is also in the VRAA, which we, I think, find compelling, is that there's some elements that are more universal and do not apply to only a handful of jurisdictions because of their past bad acts. It allows, for example, federal observers to be sent out to elections to specifically monitor compliance with language assistance in voting as required by Section 203 of the Voting Rights Act. It would provide greater transparency. Every jurisdiction would have to give public notice of changes in their electoral practices 180 days before a federal election. Every jurisdiction, not just jurisdictions that previously were covered. There's also some other greater leeway given to the federal courts to provide or to implement preliminary injunctions when a practice is being considered to put in place that would appear to be discriminatory or has the potential of being discriminatory Federal courts would have greater leeway to issue preliminary injunctions, as well as greater leeway to bail in under coverage jurisdictions that have practices that not only are proven to violate the Voting Rights Act or violate the rights of minority voters intentionally, but where the law actually has results that are discriminatory and not having to prove the intent. So there are some elements of the Voting Rights Act amendments that are universal, that would apply to all jurisdictions, which are particularly important to Latino voters where we know we have growing electorates. There's two things, though, that are quite troubling about the Voting Rights Act amendment. One is there is an exemption for voter ID laws. Voter ID laws would not be covered by the Voting Rights Act as it is currently written specifically. The second is an element that we have been advocating, and this has been championed by my colleague Tom Sines at MALDEF, who was in the room, and I guess he just stepped out. It would be to include what we have been calling a known practices coverage. So rather than covering jurisdictions because of their past bad acts, let's have actual practices being covered because of their potential or their past proof of actually discriminating against voters. So if a jurisdiction wanted to do any of the following 5 things, these 5 practices would have to be subject to pre-clearance. Things like trying to move a jurisdiction from having single-member districts to at-large elections, or a combination of single-member districts to then single-member plus at-large districts. In fact, there are some jurisdictions who are thinking of doing that right now as a way of trying to dilute minority voting. Second is reductions in language assistance. Third, polling place closures and moving polling places. Fourth, annexations. And another way to purposefully dilute minority voting strength is to add more non-minority voters to a jurisdiction through annexations. And then fifth, redistrictings, which are probably the most egregious form, what has been used to dilute minority voting strength. So this known practices provision is something that we will continue to champion. So if a jurisdiction wants to do any of these 5 things, regardless of its jurisdiction's past history, this act would have to be pre-cleared in order to be implemented. Now, it's going to be a heavy lift to try to get this in there, but something that we're going to continue to champion, certainly if not in this Congress, in the future Congress, to try to create a Voting Rights Act that is in fact modern, modernized, and deals with discrimination voting as we experience it today.
And there are 2 fault lines I think I identified here. One is whether or not the legislative response should be nationwide or particular to jurisdictions, or whether it should focus on discrimination, or whether it should focus on some other principle other than discrimination. That I think these were 2 of the issues that Sam identified. Dale, do you have any further thoughts on either of those questions?
Why not do both? No, I understand there's finite energy and finite resources, but these aren't necessarily mutually exclusive imperatives. And the VRAA, as Arturo mentioned, does have a notice provision in it that Sam was advocating. One thing that some people talk about are the recommendations of the Presidential Commission on Election Administration, which I think is, generally speaking, a pretty good document. I mean, the guiding principles of the ACLU's work in voting are that everyone ought to be able to vote, voting ought to be free and easy, and everyone's vote should count equally, right? And there are a lot of different ways of going about accomplishing those goals, right? One is through anti-discrimination work, and then other ways are, it's through the sort of more prosaic election administration issues, which really do affect the number of people who can cast ballots, but maybe aren't always as headline grabbing. So, for instance, things like expanded early voting, right, is a recommendation in the commission report. Changing the way we allocate resources for polling places, right? And this isn't something that's actually mentioned in the report, but it's something that people, I think, don't really think about when they think about resource allocation and how that affects congestion at polling places. Typically, machines and resources are allocated based on head count. You have 100 voters here, you have 50 voters there, put twice as many machines in the place you have 100 voters, right? Makes sense, seems to, right? But actually, that's not necessarily the best way to do that, right? Because you also have to take into account how long it takes the voters to cast ballots. And if you have different machines in the two locations, right, if the machines at the polling place that have 50 voters take twice as long to use as the machines at the polling place that have 100 voters, well, you actually want the same number of machines at each place, right? So there are basic technocratic things that we can do, I think, that can improve the elections process and make participation easier for everyone. The thing is, though, is that, number one, there are two problems with just focusing on those election administration issues. One, they don't capture everything, right? Because they don't stop the kinds of voter suppression stuff that we're, I think, largely here to talk about today, right? Let alone the dilutive techniques that Arturo was mentioning. And the second thing is I'm no expert on the calculus of what's politically feasible. I'm just a litigator. I sue people. That's what I do, right? But I'm not sure that working on these kinds of election administration problems, as prosaic and technocratic and nonpartisan as they seem, is necessarily easier than improving our anti-discrimination laws, right? Now, take for instance, early voting, right? One of the recommendations of the Presidential Commission, right? A week or so after the report gets issued, the Republican National Lawyers Association comes out with this blistering report assailing early voting. And you have to sit here and kind of scratch your head, like, why would you be against early voting, right? It just kind of improves convenience. And if you look at the history of it, right? Ohio, 2004, huge, huge, huge problems, right? People waiting in line 8, 9, 10 hours to cast votes, right? One of the ways they tried to solve that problem in future elections, in addition to changing the way they allocate machines, was to expand early voting. And in 2005, Republicans in the state legislature in Ohio were very much in favor of that, right? What happened? 2008 rolls around, and the picture of your average early voter shifts dramatically. Before 2008, your average early voter was older than average, wealthier than average, more educated than average, more conservative than your median voter, right? 2008, the script flipped, right? And for the first time, for instance, African Americans used early voting at a higher rate, in some places a substantially higher rate than white voters. In Florida, twice the rate of white voters. In North Carolina, 70% of African American voters voted early, not on election day, right? Suddenly, all these people who liked early voting in 2005 are all against it, right? It could just be a coincidence, right? But it's not, right? It's not because of a principled objection to the reform. It's a concern about the outcome that the reform brings, right? And we've become so polarized right now, right, that it's hard, I think, for people to view these election administration reforms, technocratic as they may seem, in nonpartisan lenses without considering the potential impact on election outcomes. And as long as that is the case, then even these simple-sounding reforms are going to be a challenge to implement.
So Gilda, what is your take on the question of, do we need legislative reform? Do we have all the tools that we need to fight these vote suppression efforts?
We can always use more tools, certainly after the Shelby County decision. And I think it is important that we not only look at statewide practices and procedures, but voting practices and procedures, whether they're on the local level or the statewide level, because we're talking about access to the right to vote. And I would submit that the genius of the Voting Rights Act was that it did not have to, while it outlawed literacy tests, it encompassed all types of shenanigans, right? Or what Dr. King called conniving methods, right? Methods that were being used and changes, and that would change over time, whether it was a literacy test or a poll tax or some other mechanism that was being used to disenfranchise, particularly voters of color at the time. And I think the genius of the Voting Rights Act was that it was crafted in a way that it could use the 14th and 15th Amendments and use Congress's authority under the 14th and 15th Amendments to craft legislation that could not only impact voter registration, but could also impact redistrictings or polling place changes and those kinds of events. And now we have this Voting Rights Amendment Act, and I've said this before, that I think that we're at a Charles Hamilton Houston moment where we need to think differently. And we need to think more expansively about the kinds of things that we want to achieve with legislation. I recognize that this is the first step. I got the talking points, right? I saw the emails, right? This is the first step that it's a good piece of legislation, but could be much, much better. And that I get the politics. We want to see what can get through. But I would hope that we could begin to think about not just what we can get through, but what we need, right? And how we can restore Section 4. Because I do believe that Section 5 was an effective piece of legislation, and that while even the Supreme Court admitted that racial discrimination in voting still exists, that there should be some mechanisms to ensure that racial discrimination can no longer impact the ability for any person, any citizen to exercise their right to vote. But again, there are tools that are needed, right? And so we still have Section 2 of the Voting Rights Act, and Sam talked about litigation. Litigation is very costly. A Section 2 case can cost anywhere from $500,000 to $2 million. And Section 2 cases are very long, right? I've done Section 2 cases, and they are very long and very expensive. Particularly with the way that we're looking at voter ID and other issues now, looking at vote denial cases versus vote dilution cases, and totality of circumstances, and whether or not you have that history of official discrimination in voting in Ohio versus Alabama, right? So these cases are very difficult. They, again, are very expensive and very long. So I don't think litigation is the answer. I believe litigation is a tool. The legislation on the state and local level is not the entire answer. It is a tool, right? So I think that we have to have many tools in our toolbox in order to effectively eliminate the barriers to exercising the franchise.
And before we turn over to questions, just one last question for the remaining panelists on that issue of litigation. The courts are where most of the action is right now, and the question is, how effective are they? How effective do you expect them to be over the long haul? These cases have not yet hit the Supreme Court again. And does the litigation strategy help us get past the problem that Dale identified, that these issues right now in the public or in the political sphere are so polarized and on partisan lines? Sam?
Well, some have gotten to the Supreme Court. In 2008, we won a case 9-0 in the Supreme Court upholding the cutback on some of the restrictions that the Secretary of State had put in Ohio. In 2012, there was cert activity by the Republicans in the Supreme Court. It was denied. So they've had their shot at it if they had truly wanted it. I think that litigation is always a partial solution. And one of the questions for litigation purposes, and I too go to bed thinking of who I can sue, but one of the questions for litigators is, what are the effective tools here? And I spoke earlier about why I think that a different set of tools would actually make the enforcement strategy both cheaper, more effective, and give it more legs in the court, make it easier for courts to go that way. But let me step back for just 1 second. What we have in this country, for terrible reasons, largely because the slave states demanded it, is local control over the political electoral process. And the local control has always been a problem in our country. The local control is where the recalcitrance to minority voting has taken place. The local control is where violence has been organized. The local control has been the source of the problem. Now, we've had 2 historic responses to that, and a third one that is perhaps upon us now. The first response was military. We occupied the South, and that was the biggest movement of minority enfranchisement that we've had in American history when we put the entire South of the United States under military occupation. I don't think that's a standard strategy that's likely to be repeated often, but we could discuss that one. The second is to take the legacy of the military strategy and go through the race discrimination prism and use the 13th, 14th, 15th Amendments, particularly the 15th Amendment, as the basis for the Voting Rights Act. And the Supreme Court said we want a greater tie-in, we want more direct nexus between what you're doing and why you're doing it. You can argue that you don't like the Shelby County outcome, but that's basically what the court said. But there's a third source, which is that there are areas that the Constitution gives over to the state, to the federal government, where the states can act if they want to. Keep in mind that when the Republic started, every state did its own census. There's no prohibition on states doing their own census, counting the people any way they want, anything of the sort. But once the federal census took over, the states didn't want to do it twice, and today we have no state censuses anymore. It's all done at the federal level by the Bureau of the Census with no state participation in its construction. Why? Because it wasn't preemptive in the classic sense, but it sucked the air out of the room. There is tremendous reserved federal power over the election system through the Elections Clause and through other mechanisms that can be used. So for example, an executive order, and I don't know if this is constitutional or whether you need legislation, but an executive order that says any federally issued ID will be sufficient to vote in a federal election has a pretty good constitutional basis in my view. Now, what is a federal ID? Well, it turns out our government gives us Social Security cards. Our government has just expanded medical coverage so that a lot of Americans are getting cards through that identify them as recipients of either Medicaid or some kind of state exchange through, but federally authorized. Put a damn picture on it. You know, it doesn't take a genius to figure out how to use an iPhone and snap a picture when they come in for these cards and slap it on there. Now you have a federally issued ID, which by executive order could be a guaranteed form of identification in a federal election. Are states really going to take the 80-year-olds who run our election system and train them that there are two different kinds of ID depending upon who's running the election, and that when they're run on the same day they have to ask for one ID for one set, one for another? If you've ever been on an election line, you know that they can barely figure out who you are under the best of circumstances, and that's just not going to happen. So there's a lot of ways of getting at this. If you start thinking about that this is a problem of local recalcitrance, and reserve authority of federal power is maybe the best way to go at it, not necessarily through the discrimination model.
It's amazing the efforts that states sometimes go to. Dale, you'll have the last word on this, and we're going to open it up to questions.
I thought it might be useful. What I wanted to do is just sort of talk about sort of the playing field right now in litigation, and just so folks know, have a sense for what the state of play is in terms of where cases are right now, because I like that Sam has said that our side has been spectacularly successful in fighting this stuff in court, but there's a long way to go. The cases we've won are going to be on appeal, and there are a whole new slate of cases. So I think by November, we're going to know a little bit more of where we actually are, and there's a part of me that's terrified that the cases we've won, it's kind of like that moment in Star Wars after the Death Star's blown up, and you think, hey, it's all good, but then the Empire struck back, right? So, so let's just, I love that things are going well, and I like that everyone is pumped up about it, but I want to have some sobering. Approach it with some sobriety. So, okay, so where are the cases right now? Three types of cases, I think challenging three types of restrictions. There are cases challenging election day restrictions, mostly in the form of voter ID laws. I'll give you four of them. There's the Pennsylvania case, which Marion Schneider is in the House from the Advancement Project and one of the trial counsel in that case, alongside with the Pennsylvania ACLU, which struck down that ID law under state constitutional grounds. So we're using the race-neutral approaches that Sam has endorsed. The governor of Pennsylvania has announced that he will not appeal, so voter ID in Pennsylvania is dead, right? Arkansas. Arkansas is another place where we've challenged that state's voter ID law under state constitutional law grounds, again, a race-neutral theory, successful in the trial court, on its way to the Arkansas Supreme Court this summer. Wisconsin, Plaintiffs in that case, including the ACLU, challenged that ID law successfully under both the Equal Protection Clause and Section 2 of the Voting Rights Act. So Advancement Project also challenged it. Again, successful on appeal to the Seventh Circuit this summer. And then Texas's voter ID law is being challenged under Section 2 by, among other organizations, the Brennan Center. So hat tip to Wendy Weiser here. And that case is going to trial in September. So there's a lot to be seen, right? Second set of cases are those cases challenging voting restrictions pre-election day, so early voting cutbacks. North Carolina got rid of 7 days of early voting, including the only Sunday of early voting. A preliminary injunction hearing in that case is set for 2 weeks. There are other provisions in that case as well, like the elimination of same-day registration. Ohio, after Sam's team successfully stopped early voting cutbacks in 2012, is at it again and has cut back early voting once again. So we brought suit a month ago to try to stop that, and there's likely to be activity on that case before the election. And then last category, challenges to registration barriers. And again, Brennan Center's litigating one case, the EAC case, where Kansas is trying to change the instructions to the federal form to force people to provide documentary proof of citizenship at the time they register to vote. Why in the world would you want to do that? Well, think about this. How can you conduct a voter registration drive if that's a requirement? Because people aren't walking around on the street with copies of their birth certificate or their passport in their pockets. So there's a lot of activity. That case is going to be heard on appeal also this summer, right? So things have been going well so far, but there's a long way to go.
So now we have about 15 minutes for questions. Go right ahead. There's someone with a microphone.
Oh, okay. I am a legal advocate in Texas, the home of one of the most egregious, some of the most egregious laws passed. And I've reached out to several national organizations. I'm very interested in volunteering my time to help secure rights of, working poor, minority. All of my client base is made up predominantly of working poor people of color. And so I've had little to no response. I'm wondering what I can do to get engaged as someone on the ground there. And if there's nothing right now that y'all know of, what I could do to maybe create those opportunities as a volunteer.
Well, where in Texas are you working?
Dallas, predominantly.
In Dallas, okay. Well, certainly I would say reach out to MALDEF, the Mexican American Legal Defense Fund. I don't know if that's one of the national groups you've reached out to, headquartered in San Antonio, but probably one of those preeminent voting rights attorneys in the country today, Nina Perales, is based there.
Yeah.
So I would start with contacting the MALDEF office. Our office in Houston actually does serve the Dallas community, but our work there is more voter registration, voter engagement, naturalization promotion. But you can certainly, if you want to work in that kind of civic engagement process, also voter protection, voter education is an element of what we do, and we could always use help in the Dallas area there. Just one other thing, just in terms of what is needed, and I think we haven't really stressed enough, is we really need to make sure that voters are informed about their rights. Because the best way to protect your own voting rights is to know what your voting rights are. And the fact is that people don't know what their rights are when they walk into the polling booth, or how to register to vote. And many people are intimidated by the voting process. Many of us think of it as being very intuitive, but it's not, especially if you're voting for the first time as a senior citizen who's naturalized. It can be a very intimidating process. So we actually need to invest more in voter education as well as voter protection strategies.
And for everybody who wants to get involved and get in contact, if you could email us afterwards, and we're happy to put you in contact with folks. I think the education point is critical. There's, really having a lot of public conversations about this would also be very helpful.
And don't forget about election protection. You can always do that as well. And LDF and Lawyers Committee and those kinds of organizations are always looking for local attorneys to help them in filing cases and other things. So reach out to those organizations as well.
Yes, I'm Asa Gordon of the Douglas Institute of Government and chair of the Green Electoral College Task Force. Pending in the district court right now is Gordon versus the clerk of the House of Representatives. And what it is, you'll be interested in, Georgia is one of the lead state. Georgia awards its electors on a winner-take-all basis, but it does not have a winner-take-all state stature. So it mandates that they must allocate their electors in proportion to the popular split in those states where there is no specific state law that the governor or the secretary of state can point to. That's pending right now. The judge in the case said that this may, it hyphens what happens when you have a winner-take-all system where it's not based on state law. With respect to what the gentleman on the right, I'm sorry, I will be holding a workshop on what is called a Taxpayer Voter ID Act. And in essence, what it said, in a government, in a country is based on no taxation without representation. Any government that accepts documentation that is sufficient to take my money is sufficient documentation to take my vote. And so the Taxpayer Voter ID Act, in essence, says that anyone who files a federal income tax is automatically registered to vote, and the state is required to send out to that taxpayer a voter ID card and registration card. That will be presented at the National Convention, and we have proposed an actual bill along that lines.
Great, and just, I guess there's no question there, but there are a lot of states that are now moving to expand voter registration and to introduce increase voter registration opportunities to modernize that system, and that's a critical path forward as well that, that we hope will pick up even more momentum.
I have a political question, I think for Mr. Vargas, but I'd be interested in everybody answering. I'm struck by the shamelessness and open contempt that many Republican elected officials have demonstrated for the Latin American community. And I had a candid conversation with a Republican colleague who said that he thinks that this is a very short-sighted strategy on their behalf, that in the long run, it's going to serve more to alienate Latin American voters against the Republican Party. And I guess I'm asking you to comment on that, and do you think that that is a correct assessment? Will this in the long run do more harm than good to the people who are attempting to do it?
I think history clearly demonstrates that those who have championed anti-immigrant or anti-Latino policies have suffered as a result. I think the most vivid example of that is California. I mean, the reason that California statewide has the type of electorate it does is because of the introduction of about 1 million legal permanent residents who became U.S. citizens after 1994. 1994 was the year of Proposition 187, which is the great granddaddy of SB 1070. It was declared unconstitutional by the U.S. Supreme Court. It would have required any public employee to report to the INS anybody they suspected of being undocumented and to deny a public benefit or service to that individual. Prop 187 passed by the electorate, but over the course of the following decade, again, 1 million legal permanent residents became U.S. citizens, and it really riled the Latino community, and it pushed Latinos away from the Republican Party into Democratic arms. Now, will the Democratic Party take that for granted is also a question that I think that party needs to ask itself. Same kind of phenomenon is occurring in Arizona, where SB 1070 has also riled up the Latino community of Arizona, has motivated voters to come out and vote. There is nothing that motivates somebody more to take action than fear and anger, unfortunately. But it has been fear and anger that has motivated Latinos in California, is motivating them in Arizona, and many people are looking for that Pete Wilson boogeyman to really emerge himself or herself in Texas to rile up that electorate as well.
There's a lot of questions.
Whoops. Hi, I have a question. Does the VRA or the Amendments Act contain kind of either bounty hunting provisions or attorney's fees and litigation cost provisions? Because they do.
Yeah, the existing VRA has attorney's fees provisions.
Not a bounty hunter.
Yeah, nothing for
there's no
Boba Fett.
There's no key Tom type.
That's what I was asking about.
No.
Let me ask this. If a effort is made to favor one political party over the other, but the effect is to have a discriminatory effect on African American voters or Latino voters. Is that unconstitutional?
This is the hardest question in this area. The Supreme Court punted on this issue in 1971 in a case called Whitcomb versus Chavez. And ever since then, in every case where the court has interceded dramatically, and these mostly the early cases, it has done so where there was no bipartisan competition. It did so either in the all-Democratic northern cities or it did so in the all-Democratic southern states. The problem in this area is that the Supreme Court, from the Warren Court on to the present, has been leery about declaring the Republican Party unconstitutional. and well, you laugh, but think about it. Think about what the implications would be if you had a court that basically said that one of the two major parties is beyond the constitutional realm of protected politics. That would be a huge shift in our republic's way of thinking about politics. This is one of the reasons that framing all these questions in terms of race has been so problematic in the courts. And if I can just give the 2-second version of the way that was gotten around in the Ohio litigation, because in the Ohio litigation there was racially disparate impact in the 2008 and 2012 rounds of litigation. But we never asked the court to make a finding of racial discrimination in what was clearly partisan motivation from top to bottom. We let them make the impact finding, but then we asked them to make different findings. There was no purpose served. The state couldn't identify a neutral principle that it was advancing. It was arbitrary. The lines it drew were capricious. On down, it didn't serve administrative convenience. So you get at this with a measure of administrative law, Administrative Procedures Act type considerations of the process for the enactment and the implementation, and let the fact of the racially disparate impact linger in the background. But I think that if the strategy is to declare a long-standing campaign of the Republican Party, the way voter ID is right now, to be per se unconstitutional, that's going to fail.
Just a quick addition. The questions of race and partisanship are so clearly intertwined in a lot of these battles. I think that at least in the Voting Rights Act Section 2 cases, that question is going to come to the fore and will be addressed at some point sooner than we would hope by the court. Would you agree with that, Dale?
Yes.
Right. Certainly when you're looking at the totality of the circumstances.
There's a lot to say about it, but that is a key issue, and it's going up, and we're all strategizing around that issue.
Hi, I'm from Fair Vote. First of all, thank you all. This was a really interesting panel. I was interested in the previous panel, there was a comment about the California Voting Rights Act and how effective it can be in vote dilution cases. And as I understand it, it's not a very big change from Section 2 to the vote dilution claims made under the California Voting Rights Act. The biggest change is that you just get rid of the one court-imposed requirement that you have to show that you can draw a majority-minority district before the litigation can even get started. And I'm wondering what you think about making, there have been state voting rights acts proposed in other states, and I wonder what you think about making a stronger push for that kind of effort, or even toward amending Section 2, maybe just to get rid of that one requirement from the Jingles case.
Would you like?
Well, I wasn't at the previous session, so don't know exactly the reference, but the California Voting Rights Act is actually a tool that we're trying to strengthen in California to try to deal with some of the losses that we have from Shelby. But one of the elements of the Voting Rights Act that has been quite effective most recently is that it does require the change from an at-large election system to single-member districts if you can demonstrate that racially polarized voting exists. And if it exists, a litigation could be brought against that jurisdiction. And already at least 3 jurisdictions have voluntarily elected to go from at-large to single-member districts, knowing that they had a sufficiently large, cohesive minority population and that racially polarized voting existed. So a state solution is actually quite viable.
I'm sorry, but we are running out of time for questions, but I'm going to encourage folks to stick around afterwards to answer questions because there's another session afterwards. I do want to close by noting that even if there are different strategies being deployed, everybody is in agreement that that this push to cut back on voting across the country is something that we need to push back against, and we need to deploy all of these tools, and we need to find the most effective ones to do so. And there's litigation, there's legislative options, and public education options, and we hope you will all join us. I hope you will join me in thanking my excellent panelists for a great presentation.